Bugün de konumuz var, 3 konuğumuz var. Alışılmışın dışında ilk konuklarımız İngiltere'den ve kendileri Avrupa Birliği hukuku ile ilgili bir konudan bahsedecekler. Arkasından da yine Avrupa Birliği. Teknik bir konu. Dolayısıyla diğer konuyu da Kadir anlatacak bize. İki Avrupa Birliği konusu, ikisi de bayağı teknik. Bugün biraz daha böyle rekabet hukuku sınırlarını kendi adımıza zorlayacağız yani. Onu söylemem lazım. Dolayısıyla teşekkürler geldiğiniz için. All right. Welcome. Hi there. We have guests from abroad, from UK, University of East Anglia, two colleagues of mine. And they will talk about the, let me read it, Portability and Interoperability under the EU Data Act. So when you read this title, it looks like it's not related to competition law, but it is in fact, at least. It's very much related to switching costs and making the environment, the data environment more competitive. So the topic is a little bit aligned to me, but I read the article, and so it's enlightening. I hope that you will like it as well. First, I'd like to introduce them to you. Let me read it, as I could not memorize. So we have Sean Dennis. He is now director of Center for Competition Policy. He's a professor of competition policy at Norwich Business School. So he's an economist, right?
That's right.
And he has a PhD from Berkeley. He has an extensive experience in government work and competition law and policy. He was a senior economist in the competition division of OECD. For 2 years, he was executive director of the Competition Commission of Mauritius. That's interesting. Mauritius should be nice. At the OECD, he developed and led the development and application of OECD's competition assessment toolkit. Prior to that, he worked as an economist at the European Commission, DG's Competition, and the US Department of Justice Antitrust Division, developing economic analysis for competition law investigations. Well, that is very nice. So he's an economist, and I think you are the first economist this year. You're the second economist in the program this year. Benjamin Evans. He's a postgraduate researcher in the School of Law, and he's a lawyer, therefore. I think you're now pursuing your PhD program, right?
Yeah.
And your PhD involves IT, competition law.
It does indeed, yeah.
And data.
Data advantage.
So very much this topic.
Absolutely.
Okay. He's a member of Center for Competition Policy. He holds an LLM in IT and IP law. So I'd like to first thank you for responding to our call for papers and coming here. The jury apparently selected your paper as a part of this program, and it's very nice to host here in person. I hope that you'll enjoy your stay here as well, both in Istanbul and this very much seminar. So I'll give the floor to you. You have your microphones. We have like 40 minutes. The time's now. It's like, let's say 10. So we're going to be finishing at 7:50. Okay?
Yeah.
Floor is yours. Thank you.
Perfect. So it's a real privilege to be here, and thank you for the extremely kind introduction. So we have, Sean and I, a shared interest also in Turkey and this country as a fascinating developing market. So we might reflect a little of our thoughts towards the end on maybe some lessons on in fact not how the EU should be followed, but how the EU might be a territory to watch and learn. We have here a natural experiment underway in the EU in cloud. Okay, so let's get into the paper. So, you know, aside from this maybe kind of difficult title to the paper, really our question is quite simple. So what we're asking is whether policymakers should indeed consider introducing legal provisions that would mandate a certain level of portability and interoperability on elements of the cloud. And the EU Data Act essentially, as Kerem alluded to, tries to address issues of lock-in, tries to address issues around switching costs, and its objective is really to stimulate competition in the EU cloud sector. So forgive me if I'm maybe preaching to the converted on this one, but I'll just kind of run through what we mean by cloud services, because I think that, you know, sometimes maybe we might think about it as an end user, as something like software as a service, maybe something like Zoom that we would use day in, day out. And indeed, that is a layer in cloud. But beyond this, we have the platform as a service layer. So the kind of customer that you'd be thinking about there would be someone like an applications developer. The platform layer provides the building blocks, shall we say, for programming and deployment of applications that are hosted on it. And if we think about the infrastructure as a service layer, so kind of the base of the pyramid, so to speak, really we can think of that in terms of providers renting infrastructure that can be, you know, a combination of physical and virtual machines, networking, storage to customers. And the great advantage, so the reason why I think it's fair to say that cloud is revolutionizing international commerce, is that it's allowing firms tremendous flexibility. So as opposed to you know, previously having to make really very significant capital expenditure in these IT infrastructures, they can on demand tap into as much capacity as they need. So cloud is of huge significance because it's really a base layer now. It's a base layer infrastructure. And hence the EU and other jurisdictions are getting very, you know, very interested in it. And what we're seeking to do here is take a little bit of a law and economics lens to critically assess, in particular, the way in which the Data Act is attempting to deal with those issues of lock-in and switching costs. So again, forgive me, because we're probably all really familiar with this, but we thought we'd map out just a little bit of cover kind of some of the basics on EU law and regulation. So if I refer here to in the EU ex post competition law regime, we have as the cornerstones of this, we have Article 101 TFEU, and that's dealing with anti-competitive agreements, classically dealing with cartels. And then we have Article 102 of the treaty, which is targeting abuse of dominance. Then when we move to ex-ante regulation, we have merger regulation, so trying to address ex-ante potential anti-competitive issues arising from mergers. We have relating to data, the very well-known flagship GDPR in the EU, which is kind of becoming a template for other jurisdictions, essentially regulating the use of personal data by firms and giving certain limited rights to users. We have the Digital Markets Act, which I think enforcement day might even, or kind of first kickoff day to an extent, is today, which is really interesting. This is regulating a small subset of so-called gatekeeper firms who, let's say, haven't been captured adequately, the Commission would argue, under 102. So we're dealing with abuse of dominance, but under a whole different name, and it's ex-ante, so it's essentially placing positive and negative obligations on firms to address their conduct. We then have the Digital Services Act, which is regulating digital content providers. And then finally, here, and this is just a selection, by the way, of the kind of explosion of EU laws, and regulations for digital markets. But finally, we then have the Data Act, which is addressing fair access to and use of data. And so just to the reason we've put this little kind of chronology out here is that the Data Act is extremely new, and it's a tool that we think demands proper justification. You know, we've got here a very significant toolkit already for dealing with competition issues. And I think that as you'll see as our presentation goes on, one of our messages is very much, you know, think before you regulate to a degree here. We really are looking for evidence of a significant and broad-based market failure to justify intervention of this nature and questioning why other provisions aren't sufficient. Okay. So competition in the cloud sector is an interesting one to think about and to characterize. And so what we map up here, I guess, is something of a simplification of things, but we think that it's an interesting starting point. So, you know, cloud started out when Amazon essentially opened up its proprietary IT infrastructure, and it created a market. And suddenly we had you know, some firms like Microsoft coming in who were trying to compete for a different set, right? A different set of customers. They saw something, they tried to create a new offering. We had actually a very interesting, what we would refer to as kind of inter-cloud service competition going on, where it was tremendously dynamic, focused around service innovation. The competition was for the market, and driven by customization. And what the regulator envisages is something a little bit different. So the regulator is envisaging a world in which we call it intra-cloud service competition, in which competition occurs between services of the same type, equivalent services. And this is rather more of a static way of thinking about things. Competition, therefore, is very much in a given market, and the regulation is pursuing, to a great extent, standardization within markets. Now, what we feel would be a far more prudent road to go down is to be pursuing dynamic competition in those markets, okay? And what we're worried about is that the dynamism that hitherto has really characterized cloud competition is going to be lost and diluted as we push, or as Europe pushes for standardization, open interfaces, and the like. So this is the vision, and this is what we are looking to inquire about. So if I just lay out some of the foundational concepts. So this notion of equivalence, so if I just go back, so the objective here is to pursue service equivalence under the bottom figure. And what do we mean by equivalence? So in the Data Act, equivalence is defined in terms of same service type. And services of the same type are a set of data processing services that share the same primary objective, the same data processing service model, and main functionalities. And what we think is really key to note here is that this is an assumption that actually represents really an analytical shortcut on the part of the legislator. So, you know, we actually find that whilst there is some attempt, and the attempt is there in the recitals to exemplify how you can distinguish between these services of the so-called same type, there isn't actually sufficient clarity that's provided in order to establish a clear legal standard. That you know, if we think of cloud services here as an incredibly diverse and rich array of services, serving clients with extremely heterogeneous demand and needs, then we don't think the regulation quite hits the mark on its definition. And actually what we find is that it's really only fit to serve as very much an initial filter. So, it's able to capture something broad, but what can you do with that? We feel regulation should mirror the discernment of the customers. And so that is an initial shortcoming in this definition of equivalence. And indeed, even where we might have like a notional equivalence, we would say, in fact, it's interesting that these cloud providers are competing so vigorously and assiduously to meet the specific, often customized needs of their clients, that in fact, the implementation of a notionally equivalent service might be very different between service providers. So moving on to functional equivalence, and Sean will dive into this shortly. I just thought I'd lay out really what the definition is. Forgive me here. Essentially, if I say in a nutshell what the definition is looking to do, it's looking to mandate that when a customer is switching, that in response to the same inputs to the new provider, in response to the same inputs, the same outputs will be generated. So if you think about a destination and an origin provider, well, this puts a huge onus on that origin provider. Yeah, huge onus. So what we're concerned about is the depth of incursion and level of burden that it will place on infrastructure as a service providers. So not only do they have to ensure, and I think it's worth just emphasizing it, a minimum level of functionality and the environment of a new data processing service of the same type after the switching process. Okay, not only do they have to do this, but they have to kind of summon all of the tools at their disposal to ensure that this is facilitated in an incredibly comprehensive way. So facilitating the switching process involves providing capabilities, adequate information, documentation, technical support, and necessary tools, which, as I'm sure you can imagine, may very well involve a lot of intellectual property or material covered by trade secrets law. So this is really a very heavy burden that's being placed upon cloud providers. And we find that actually, even though it's clarified that this should only be placed on infrastructure as a service providers, so we're thinking about here, a relatively small number of those cloud service providers, we still would underscore that, in fact, on paper, it's easy to differentiate and say there are these different service models with a clear boundary between them. But the technical reality is that the boundary between infrastructure as a service and platform as a service is immensely grey. The boundaries are very much blurred. And so again, if you've got a mandate such as this, okay, if you're placing this level of obligation on providers, we feel that there should be a huge amount more of a realization of the technical realities of the industry. You might hear capture firms that are indeed the wrong firms. Okay. So I'm actually going to come back and revisit this notion of custom built, because I think it would be fantastic for us to move into a little bit of the law and economics side of things. And I'm going to move forward to Sean just to discuss functional equivalence from an economic perspective.
Okay. Thank you, Ben, and it's really a pleasure to be with you today. So the origin of some of the concerns with the Data Act is that certain companies who are users of cloud services complained it was very expensive, the cloud services they were receiving, and very hard to switch. And so with that existence of some complaints and relatively little evidence about the frequency of those complaints, by the way, but some complaints, the legislators chose to think a little bit by analogy. This is similar to the telecom services with mobile telephone services, where you should be able to move your number from one company to another. Or banking services, where there's an idea that you should be able to move your banking services very smoothly, almost transparently, from one bank to another. And some countries have gone a long way to implementing that type of movement, like the UK. United Kingdom has a bank switching mechanism in place, which creates this kind of very smooth movement, which is what the legislator is trying to create for cloud services. Now, the thing is, my view is that cloud services are a completely different ballgame from banking or telecom services. And the reason is they're extremely customized and complex. And if you think about a bank account, a standard bank account, I'm going to ask, how many variables are there really in the construction of a bank account from a business perspective? And maybe there are 5 or 6 things that matter that we would differentiate, that we look for when we're choosing a bank account. If you are a consumer of cloud services, you have a lot more variables, I'm going to call them variables, that you are looking at. And so maybe it's 20, maybe it's 100, but it's an enormous difference between that and a bank account. And what the legislator is effectively trying to say, and especially in the very earliest drafts of the Data Act, but still in the version that's been finalized, is that we want a customer to have a transparent movement experience from one provider. So say they move from Amazon to another provider, say they move to Microsoft. And the reason the legislator cares about that is they think if the movement experience is very smooth and easy, that will create easy switching, which would constrain the ability of any individual operator to raise the prices too much. So I'm sympathetic to that type of competition reasoning, but I think it doesn't work for a very complex product. And so what I'd like us to think about is the number of variables that we actually have in this product, and then the variance within each variable. So there's a lot of variation for each of these categories as well. And in a bank account, I don't think there's that much variation within the features you would get, but for cloud services, there's quite a bit of variation. So now I'm going to move over to the other side of the room and try and give everybody a fair shot at this. So one example of a variable might be the speed of the server response to an input. Okay, so that's it can be slow or fast, and so that would be the variance in that type of variable. And the point is that implementing a functionally equivalent offering between providers, for banks, I'm not very concerned about it. For cloud services, I'm extremely concerned. And it's not just because of the complexity of the offering, it's also because of innovation. So if companies are being required to interconnect perfectly, what that means is that if I'm I'm Amazon, let's say, and I'm offering a certain product, there's another cloud service company that's an innovator on the market, that's new on the market. They have to offer exactly the same thing I do. I have to offer, whatever I offer has to be movable to them perfectly. So if it's movable to them perfectly, that means there can't be that much unique intellectual property built into any model. There can't be very heterogeneous offerings that are given. And if you get into this business, you'll see that for some activities like banking and finance, there are very different needs of the customers than for other activities. And so companies, when they are if they're interconnecting, so the cloud providers interconnecting, would need to have exactly the same set of features. Now that's a little bit odd for a business where in practice, right now, there are a lot of different features for different companies. And so these variables really, really matter a lot in terms of how you as a cloud provider are competing for one business or another. And if you have to have exactly the same offerings, it's going to completely change the nature of the initial competition between cloud providers. And one of the main points is that if you develop a new feature that requires costly investment, you somehow have to make sure that new feature that you have invested in creating is available on your competitor. So my question to you is, what incentive would you have to develop a new feature if that's going to be the requirement? And so I wanted to just give a sense of how much innovation is actually happening here, because this is an innovation market. And so I just looked at some patent data and searched for the terms cloud computing and bank account to give you a sense of how much innovation there is in the banking account area and how much in cloud computing, just using the US Patent Office data. And you can see that the gray lines here are cloud computing number of innovations, and the orange ones, if you can see them at all, are the bank account innovation numbers. And cloud computing is massively more innovative than bank accounts by this type of comparison, which is imperfect, but gives a sense of what's going on. And then the other point I wanted to make is I was asserting there's a lot of variation between the offerings of cloud providers. This is not something I'm just making up. If you look at compare and contrast services that try to help users, so businesses who are subscribing to a cloud service, choose between them, I found one that lists about 22 different features of cloud services and said which companies had which feature. And there were 9 companies included in this comparison. And it's just explain to you how to look at this chart. For the top 5 features, so that's 17 through 22, almost all the companies have that feature. Okay, but that's 5 out of 22 features that they almost all have. And then as you go down this table, there are more and more features that are less and less common. So the point is there's a high level of differentiation. So for feature number 11 here, there are about 33%, 34% of companies that have that feature in their offering. Okay, so that means more than 60% don't have it. And there are a lot of features that are like this, that are present for some, but not for others. If the legislator requires a uniform feature set, that's almost denying reality, the reality that jumps out of this kind of data. And so that's my big concern with heterogeneous features. We need to be thinking about the impacts of a functional equivalence requirement, which will be not only to require all features to be the same effectively across operators, or that innovation be shared among operators. And I think there are a lot of, the likely impact of requiring innovation to be shared is that no individual company can fully benefit from the innovation it undertakes. And so innovation will likely fall if a full functional equivalence is pursued. So I'm going to hand back to Ben now and see what you might want to say next.
Thank you, Sean. Yeah, so I guess that really this is a story of I guess a slow march towards the lowest common denominator is really our concern. If I can pick up on maybe a few more of the legal points that jump out. So if I skip back to the point that I was going to raise around customization, something very interesting has happened during the course of the drafting of the Data Act. So Sean and I, it's about a year ago that we published our first working paper on this. We hit this at the time of the trilogues in Europe. So the trilogues are a discussion between the Commission, the Council, and the Parliament, and they come together and discuss the three texts that they have essentially adopted in each of those chambers. And our paper was arguing, as you can see from Sean's discussion here, that we're here dealing with an industry that's characterized by high levels of customization, high levels of differentiation between service offerings. Now, what happened was that in the final Data Act, which was published very recently, a new, let's call it an exemption, was put in. And we understand from discussions with people who were close to this process that indeed we may very well have influenced the drafting of this text. We won't take credit for it, but we'll suggest that it's a possibility. Now, the custom-built exception is interesting because what it does is it does provide that where certain features have been developed essentially almost exclusively for a single customer, that those features can be carved out, can be exempted from functional equivalence. Now, that might sound, on the surface like a solution to the problem that we've just highlighted. But as a lawyer, when I read this text, I don't know what on earth custom-built means. There is no clear definition of custom-built. And the reality is that this is this notion of custom-built is something that is not binary. It functions very much on a sliding scale. And so what we can foresee is a potential scenario in which you're not aiding the switching process through such an obscure or nebulous definition here. In fact, you may be forestalling it, because what's going to happen, you're going to end up with litigation that's going to try and clarify what does custom-built mean. And we're dealing with providers who have got more than enough in the coffers to prolong that kind of litigation. So custom-built is a step really in the right direction, and we're delighted to see it. But search through the recitals as you may, no sufficient clarity is there. So it remains very much an issue. So I'm going to move forward and just address really shortcomings in both portability and interoperability. I've alluded to this already when I've discussed the reality that we don't have bright lines between these service models. So we don't have bright lines between infrastructure as a service, platform as a service, and software as a service. Rather, it's very much a continuum. And what I'd like to highlight here is just an interesting point we feel that's kind of overlooked, but it's a point that's in Professor Chris Millard's Bible on Cloud and Cloud Computing, which we would have hoped the regulator might have had a skim through. But when we're talking about portability, data portability and application portability are two very different beasts. They're really very distinct concepts. And so whereas we might think here, so if we think about a customer and their level of sophistication, we would expect a customer of infrastructure as a service products to be rather sophisticated, to ex ante at the point of entering into the contract, have already dealt with this trade-off between options to switch, between portability, between interoperability, and customization. This is a trade-off that would have been made at contract stage. So we're wondering whether to cover those very sophisticated customers under this piece of new regulation is indeed needed at all. Okay, when we skip to the software as a service level, which is often, in reality, small businesses or ourselves, as individual users, then there might be a case for addressing some of these issues, but it's more likely to be at the level of data portability than application portability, and we just think that the regulation should take note of that. Interoperability, I'm going to not spend too much time on because we really have just one key point on this, and that is that interoperability would be really interesting to address. But as it's written in the text, in the legal text, it only actually deals with facilitating or making easier data portability. We think that's a real oversight because interoperability may be something that's worth considering both on the horizontal and on the vertical axis, and it's just underexplored. So as far as we're concerned, if the only stated objective of interoperability provisions is data portability, then to extend those to mandating open interfaces, mandating standards, we think that's a real step in the wrong direction, isn't justifiable. We'd like to hear an adequate justification for that. Okay, so sticking to the legal side of things, I'm just going to, so we highlight here in red the areas where we think issues remain. We highlight in green here the areas that I've mentioned. So, bringing functional equivalence to a narrower position through this custom-built exception being a positive. Also narrowing scope to a certain subset of providers as a positive. But as you can see, there's plenty still in red. And so in the time remaining, I'd really like to address what Sean and I have thought of very much as this myth of modularity. So there is this obligation for unbundling, where technically possible, data processing services from other data processing services provided by the provider of data processing services. Thank you, EU, for a really splendid definition to get your head around there. Essentially, the issue for us is that this is importing from other regimes. We talked about telecoms. This is importing from other regimes, this kind of building blocks approach that you can somehow dive into a very complex service and pull out one aspect of it and unbundle it in order to improve the competitive situation. And we find that with cloud, where it's highly complex, hugely interconnected, that actually that technical separation, it isn't clear that that is indeed even possible. Technical feasibility comes in to this notion of modularity. So here we see that unbundling is to be done, but only where technically feasible. That would be fantastic. And it's really welcome. But again, a little bit like the point I made earlier about custom built, it's not without problems. And we actually again foresee potential litigation over really what the true meaning of technical feasibility of a given provision is. And so ultimately here, we also now go into some territory that I think Sean and I both think is very sensitive indeed, which is the regulation is starting to get into the field of mandatory contract law. Okay, so I'm going to come on to it in a moment more specifically, but just looking at how providers are contracting with their clients, we here have a requirement for the provider to notify a customer within a 14-day period of making a switching request. This was 7 days in an earlier text, to essentially say this is unfeasible. And then a period of 7 months for essentially an alternative transition to be agreed upon. Now, that kind of a short window might be acceptable and adequate in an industry where you're dealing with less complicated offerings, and maybe where you're dealing with contracts that are quite short run. But the reality is that in the cloud sector, the contracts, as we've seen, and following discussions indeed with people in the industry, we see that the norm is kind of 2 years. Yeah, these are long-run contracts that involve very significant investments at the outset. And so to start playing with it in this way is potentially dangerous. So imagine timetables like this if you're a small cloud provider, the kind of provider that this regulation, remember, wants to help. You might struggle tremendously to meet a 14-day deadline to explain why something is not technically feasible. On the contract front, because there's a little bit of time remaining, I note, I'll just raise this, which is, and this is perhaps the most egregious for me kind of imposition, which is that there is this imposition that customers should be able to terminate their contracts within 2 months. Now, if I just, as I just laid out, we're dealing here with long-run contracts. Who's this going to harm? So if you can imagine a scenario in which Microsoft receives, or any other very large firm receives a request to terminate on something for which they've invested and made predictions and investments over a much longer term period, they can potentially amortize that loss. They can amortize that switching cost, which is the burden is on them here, across a much bigger portfolio of products. A smaller firm is far less likely to be able to do that. And we would foresee that if this happened en masse, you might have a situation where foreseeably, actually, the ability of that smaller cloud provider to, let's say, raise finance might be undermined, because what's the logical outcome here? Your long-run contracts could be cut short within a 60-day notice period. So it creates great uncertainty, and uncertainty in the wrong place. So for a regulation that's seeking to help those SMEs, that's seeking to help those European companies that are trying to compete with the large incumbents, actually, the perverse outcome is that you might indeed be harming them tremendously with this regulation. And so I don't know if, Sean, you'd like to make a further concluding point?
I'll just mention that we're not exclusively interested in EU legislation here. We are interested in what policies make sense for governments to implement wherever they may be. And so the reason we focused on the EU is that the EU was the first major jurisdiction to put cloud-related terms into legislation. And right now, where we are living in the UK, there is a major investigation taking place of cloud services, and a very real possibility that some of these same concerns are absolutely arising also in the UK. I think they will arise in other places as well. And a simple copycat approach to legislation, which could be one reasonable alternative in some areas of legislation, where you say, what did the EU do? They moved first. Let's look at what they did. Oh, that makes some sense. Let's repeat that in our jurisdiction. That's a bit of a dangerous approach in this area. And that's really one of our additional points. So we think that the EU legislation is likely to create some unintended consequences, And copying that legislation would be a bit of a mistake. If there is to be legislation in this area, we would hope that it could learn from this experiment that's taking place in the European Union and perhaps be somewhat different and take account of the points that we're raising in this paper.
Fantastic.
Yeah.
Yeah.
Thank you very much for this inspiring presentation. Before turning to the audience, do you have any questions? Is there anyone who wants to ask questions? Right.
Welcome again. My name is Başak. So I wanted to ask you did you ever think that this might be an intended interference of EU? Because this is a very technical area, which most of us don't really understand the technical stuff.
And I'm going to ask a technical question right now.
Okay. Well, at least I don't really understand it. And we also see that technological companies are getting bigger and bigger, and they are a bit harder to control by governments. So do you maybe think that this is an intentional act?
Yeah. Okay.
Thank you.
Maybe I'll jump in on this one. So I've written a book about the political economy of the internet, which is called Internet Empire. And so kind of it leads into this type of question, which is that the EU is way behind in having its own enterprises to do some of these digital activities that have been so well developed, I would say, by multinationals. Most of those multinationals being based in the U.S. And so they do have allegedly some interest to create an environment where European companies could themselves grow and succeed in this area. And I think they're right to be concerned about their position in terms of technology development. If you were to look at the top most capitalized digital companies in the world, the European Union, which has a larger population than the United States, comes in first entry, number 35 or so on the list of level of capitalization of digital companies. It's a remarkable failure. But I don't personally believe that this type of legislation is going to be the solution for them. I think what might be required is a much broader reform of the ways they reward innovation, their tax structures, their financing structures, so that instead of companies being developed in the EU, and then if they have a good idea being bought by a US company, which has largely happened up till now, they may need a better financing mechanism internally and more of a innovation incentive structure within their territory.
And if I can just jump in as well. So I think that in particular, when we raise this point about standard setting, I would just underscore really that to engage in standard setting at this stage, we think is really an error. It's far too early. And indeed, we're concerned that the standard that will be set is the standard of the incumbents. Okay, so who's going to be at the table, the negotiating table with the EU body on setting standards? Who are the firms who ultimately at this stage have control of particularly the infrastructure as a service and platform as a service layers? You know, it's that small handful of firms. And so there is a real risk that until we have seen whether or not market solutions address interoperability, for example, which we're very confident about, in fact, that is a possibility. Until we've seen that, we just think it's a way too early an intervention that could do the opposite of what it's intending. It could I know it's a controversial thing to say, but I think that an awful lot of regulation actually just cements the position of an incumbent, unfortunately. So that would be where I'm at.
Yes, I think you mean EU is gun jumping or early regulation before network merges. You need networks merge and then separation between networks and services. Then you can do unbundling and service interoperability or something. As far as I understand, I don't know the technicalities, but there's no network yet in this cloud computing. It's like one network or similarities between them, and then service providers under this network. Then you can do unbundling and you can do this obligation of switching between the services. So without network, if you bring them, it always supports the incumbent. I agree with you.
Yeah.
But why it's too early? I mean, why is, I don't understand. I mean, I agree with you. It's too early to bring to cloud computing business, even though I don't know the technicalities, but I can feel it. But why it's too early, and when it will become this network and we will discuss unbundling, then we can discuss this switching obligations or something. I mean, will it turn to be network at all sometimes in the future? Then what kind of regulation we can have as a national country? I mean, okay, EU was already there, but let's say Turkey or the UK. Will it be a kind of network industries, this cloud computing, as in a technology way? And then when it will be, and then what we can do after that? Three questions.
Three questions. Okay.
Okay, so I won't answer them all, but I did jump in.
Dive in.
So if let's suppose Turkey adopts the same legislation as the EU, what would you expect to happen for one of the large cloud service offerers operating in Turkey? I think, and this is what I would expect in the EU as well, they might reduce the level of services they have that they offer in this territory to make sure that whatever they offer here is transferable to another company that's operating here. They keep it simple because that's the only way they can be guaranteed to comply with the law. If they keep it simple here but complicated in the United States, I can guarantee you that the innovation will be going much better there than here, and that's a perfect way to slow down innovation in the EU, in Turkey, places like that. So that's a bit of my concern. Now you might wonder then, and part of the reason is we don't know what all the features are yet. We don't know what the right set of features is to standardize, and there's so much variation now. It's hard.
Will we ever know those features? I mean,
yeah. Well, if it becomes like banking, then perhaps. But I think the features will always vary a lot by sector of the offering. But it remains to be seen. When there's more standardization among features, then I think it might be at the same time too late to have a kind of requirement of making it easy to move. And so I accept that there's a major challenge here of when to intervene. But I would hope that if one intervenes, one does it in a way that it's not going to handicap future innovation in a territory.
Yeah, and there's kind of an opportunity, I think, for firms. We're aware that, for example, interoperability is almost like a business opportunity, in fact, for cloud firms. So, where there's a situation, of, let's say, some large incumbents not offering certain functionalities, certain portability, certain interoperability, then there's already a business opportunity that's being seized by some smaller players to come together and to say, okay, well, we create our own kind of sub-market within cloud with some of the interoperability and switching features that the customers want. They can go here for this, they can go there for that. And so, we would just be be reticent, I think, about jumping into regulation of this nature. And I guess one thing to note is that this isn't, you know, some kind of a targeted regulation at very dominant firms. This is horizontal and symmetric. So, you know, horizontal and symmetric plus mandatory contract law, which I can't abide, right? This is going down a road that's really serious. Not even the Digital Markets Act, which has, let's say, some clearer objectives, let's say some grounding in competition law. Not even the Digital Markets Act goes nearly as far in many areas in terms of its obligations as this. So, you know, that's yeah, I think there's, you know, for the UK, as Sean's mentioned, we seem to be heading in a direction of copy paste, and I guess our kind of you know, note here for Turkey is don't necessarily just jump into that. There's maybe a great opportunity for this hugely exciting tech market here to seize the innovation challenge. And why not poach talent from Europe? Why not seize a chance to be an innovation center in cloud? That would be my thoughts.
Thank you.
Okay.
Is there another question?
Hello, it's Duruhan from Baker McKenzie Istanbul office, and we're so lucky to have you. And I have a question from the 2 weeks prior to OECD event. We've discussed a similar discussion, and I've just written my question down, if I may. With regards to the technical feasibility requirements and the quite tight deadlines, what do you think about the killer acquisition risk that the small undertakings may face against, since they may not always be able to comply with such requirements in a short amount of time? And should we think that larger firms would eventually help the smaller firms by acquiring them, and consequently their innovative products would survive through these acquisitions, which was sort of one of the arguments in the Illumina case, as far as I remember? Or would these still be considered an anti-competitive acquisition? And I guess there's a fine line between the consumer harm and the survival of smaller companies. But eventually, do you consider a risk of reduced interoperability, which would maybe cause a greater harm on consumers?
Just one, I'll quick point and then hand over to Ben. If differentiation is allowed, I would think this is one of the ways that smaller operators can grow and succeed in growing. So this legislation may make that differentiation less easy. And then if you're a company looking for a cloud provider, and you have a choice between one proven provider that's very large, you're quite comfortable that they can guarantee you the services you need, and another that doesn't have, that's small, that's new, that doesn't have any differentiating feature, then I think a lot of businesses would choose to go the safe route. And so there's almost a built-in killing of the new companies through that mechanism of equivalence. But then in terms of acquisitions, I'm not sure what approach the European Commission would have, for example, in this area where they've obviously shown a legislative concern about acquisition, about the market development. Ben?
Yeah, I mean, just to echo what Sean said, really, which is that, so if I flip this and think about what does this kind of regulation do for entry? You know, if I were a small firm, I would read this as, you know, a de jure entry barrier. Yeah, this is a legal entry barrier. So the issue here, I think, is even at the nascent stage. If we fast forward then to mergers, you know, I think that the way that I read what is coming out of both Europe and the UK, I think absolutely there's cause for concern. There's cause for concern that mergers that might ordinarily not really tick the traditional boxes might be under the radar here. Who knows if there will be special guidance that's targeted at this sector, given its infrastructural importance. That is certainly a potential. But just on this point about killer acquisitions, I mean, Sean, you might know this far more so than I, actually, but the empirical evidence on killer acquisitions in tech, I think, is somewhat weaker than in pharmaceuticals, for example. And so I guess that I might be a little bit unpopular or controversial and say, let's not even get into killer acquisitions till we've got some proper evidence that there are issues in the tech space. But I'm not sure that's the approach that will be taken. Yeah. Okay.
Thank you.
One last question.
Go ahead.
So, first of all, thank you for your presentation. So there are some obligations in DMA, such as data portability and interoperability. So if a cloud service provider designated as a gatekeeper, so it might have to allow data portability and interoperability to other undertakings. So are there any provision that in Data Act or DMA that regulates the interplay between DMA or Data Act, or any debate in EU competition law regarding this?
Sure.
Yeah.
Do you want me to? Yeah. You hit on
Legal question.
a legal question. Well, I'm going to give an answer that again might be slightly unpopular amongst some circles, but I don't think the Digital Markets Act can technically cover cloud services. I don't think the cloud services fall under the definition. And what you'll see, so the reason for that is that to be designated as a gatekeeper, you are essentially intermediating between two sides. Yeah, cloud is a traditional contract between two parties. There isn't an intermediary here. You are buying a service. You're not into a cloud. Microsoft, Amazon, they are not intermediating here between a business side and a user side. It's a very different model. It's a traditional IT services model. So I would argue that for that reason alone, when it comes to, and I'm jumping the gun by saying that I'm kind of right on this one, but have you noticed no cloud service providers are being designated at this stage? And I think it's because the EU has realized that indeed they're on thin ice on that one. And actually, I don't know whether you'd like to say something about it, Sean, as well, but the fact that these cloud provisions were raced through and shoehorned in to the Data Act, which came after the Digital Markets Act, I think it was also quite telling, because I think there was a sense in which, cloud wasn't dealt with in the negotiations, the discussions of the Digital Markets Act as a centerpiece, and had become potentially quite forgotten, or to my thinking can't even be designated. And the Data Act reads, therefore, as this kind of knee-jerk response to say, gosh, we better put something in. As to the interplay, if we get to a point where we're dealing with cloud under both, we're in for a really interesting journey there, because I think that's an unresolved question. I don't know if you wanted to.
No, nothing to add.
Perfect.
Any other question? Very basic one.
Yeah.
Maybe it's too basic that I missed the whole point. So let's make a concrete example. So I am a customer and I want your services. You are Amazon, right? So you're providing various services, various features, and I make a contract with you. So the idea is apparently that let's make switching easier, and let's make the data can be easily transferable to another service provider. So that's very easy. And what your argument is basically, well, these are different services because of different features, right? And here, the principle of equivalence comes into play. And what your argument is that it functions as a rule that will undermine eventually innovation because it will suppress the incentives to offer different varieties, different features for your services. How does it actually function like that? So, for example, which standard are we going to take? Like your standard, they have to be standards. I understand that, but which standard? So you are the incumbent, and I'm taking your service, and I want to switch. What happens?
Yeah, the legislation does not specify how that standard problem will be resolved. So it could be, but well, except to say that whatever you offer, the client has to be able to move somewhere else.
So you're offering this and this, right? So you have to offer the same. So you have to drink half of the water until there, and it will have to be safe. So the new provider will have to meet the standards of the incumbent. So is it the case?
I think it's the reverse,
Yeah,
right?
the reverse.
So this is suppose that you're offering more services than me. So Ben's offering more services than me, but you're the client with Ben, and you say to Ben, I want to move over to this other company. Then I think I can say to Ben, I need your technology. Give it to me.
Yeah,
but he's going to charge to you for that, right?
It's not very clear how that would work. I think.
We didn't address price in the paper, but price is a really interesting other aspect to this.
So if I'm not mistaken, there's a provision in the law which says that for the 3 years period, if there will be a service provided for the standardization, the incumbent can price it, but after 3 years, the incumbent won't be able to charge anything to the customer. So maybe pricing scheme can perhaps alter the incentives. Could that be the case? I mean, if I charge it, but of course, those prices should be regulated as well. We won't be able to charge too high. Oh, okay. Yeah.
Yeah, Ben, why don't you go on this one?
It's far out. This is
context or
not at all. The pricing issue is something.
So if the initial argument of the legislator is the prices are too high that Ben is charging to customers, so I should be an alternative, but Ben's going to tell me basically the price I have to pay to offer the same services as Ben, I don't think it's very likely that I'll be offering a much better deal than Ben until 3 years out, right?
Yeah, there's a 3 years grace period or something.
Yeah,
like that. I read it somewhere in the it's a 71 pages act. So
that's right. The egress
lost a little bit, but
also the egress fees are for moving data.
That's right,
and it's not for features.
No.
Okay. So data might be your pictures or your database, your Excel file, right? But what companies actually do on the cloud is they replicate their whole internal operating mechanisms, which is much more complicated than moving data per se. And so that's why for you to move your data from Ben to me is relatively easy, computationally speaking. To move the features all over requires a lot of other things. And we have to be able to have the same software, the same input-output patterns for processing the data. So imagine the next step. Okay, so just let's go forwards, AI on top of cloud services. AI builds its knowledge from what's in one place. Now, if you're using Ben's AI and you want to move over to my cloud service, what exactly is going to happen to Ben's AI, which has built on potentially all the data that's over in Ben's side? Does Ben have to give that to me? Do I get to buy that from Ben? Am I supposed to develop my own? And what is the pricing if he has to give me anything? It seems a very hard problem to solve. And it's a bit mysterious to me what's actually going to happen on this front. Because actually the AI side is going to become very important in the future for cloud services.
Right.
And in the middle of all of that, what we can't forget is intellectual property. So you know, in the process of achieving functional equivalence, where the onus is on this origin provider very much, you know, we are deeply concerned, and so the final text has tried to address this with some trade secrets provisions. And there are much clearer provisions for protection of certain types of assets that originator firm holds. But you know, if they're going to comply with the letter of the law as it says, they're going to do all of these things in order to facilitate that switching process, to facilitate and ensure functional equivalence. It seems inevitable that some kind of proprietary material is going to get shared, that they would never at the stage of investing in creating that IT infrastructure, that intellectual property related to the IT infrastructure, you know, they would never have conceived of that. So it does something about innovation incentives, I think, there, which is concerning.
Yeah. And so I mean, I think we need to think more about what would happen in the future, and with AI being on top as well. It's complex, but it's the forced equivalence between services is not guaranteed as the solution, I would say.
Well, thank you very much. Thank you for the
Thanks.
presentation. Thank you.